Hi everyone, welcome to our Unit 6 PowerPoint. The topic of this PowerPoint is billing. That is a terrible word. I don't really want to come and talk to you guys about the concept of billing. It's just one of those words that for most of us evokes an awful feeling. But here's the reality. Law offices, and by that I really mean the traditional law firm, not the government entity and not the business or in-house legal counsel that is fortunate enough to have their own in-house legal offices. But for the rest of us in the traditional law firm law office, we have to bill. We know that. We've been talking about that for a few weeks. And the reason we have to bill for our time, as we've talked about, is because that's how we make our money. That is how we pay to keep the electricity on. That's how we pay our employees. Because as this chapter and the few around it really stress, the law firm and the law office at the end of the day is a business. The business that we provide, of course, is the legal advice. But because we are a business, we need to focus on how we pay ourselves. And that's just a necessary evil of how we do work. So I only made a few slides here. There's not a lot I need to emphasize for you, but there are a few key points I want to make sure that we take away from how billing in the law office works. So, and I think some of this we hear because it's in the movies and it's in books and it's on TV, how lawyers are billed and how they're paid. But it's important to know the differences between how lawyers and paralegals bill clients for their time, because that affects how we collect that money. And you'll see throughout your work as a paralegal that how we bill our clients can depend on who the client is and the nature of the work that we are doing for them. It's not always a one-size-fits-all billing arrangement. So it's important to know the differences because you may come across these in your law practice. Okay, so the three types we'll focus on here are a flat fee, an hourly fee, and a contingent fee. A flat fee is really the easiest to define. A flat fee is the type of fee a law firm will charge for a service, a legal service that it provides, where the fee itself is fixed, meaning this is the amount that the client is going to pay for the services, and the amount will not be less than that, and the amount will not be more than that. And where we usually see a flat fee is in transactions that are less complicated, a little bit more routine in nature, don't require extra legal research or extra strategy. That doesn't mean the client's work is not important. It just means that a lot of the work is more mundane. So this might be common in an uncomplicated real estate closing or a relatively straightforward will. The client can be charged a flat fee for that legal work. What that means is if it takes the attorney 2 hours or let's say 5 hours to work on the real estate closing, or the next time it's 6 hours, or a different client it's 7 hours, that flat fee remains the same for the work that's being done. So that is what we mean by the flat fee. And again, if complications arise, that's a separate scenario, but the flat fee is very popular for those more routine tasks. They're also really popular for clients because they go into the situation knowing exactly how much they're going to pay for this service from the beginning, and it's very clear. All right, we know that's not the only way because you can imagine a scenario where we just don't know how complicated a legal matter is going to be. We don't know how long the representation is going to take. So the most common way to bill for time is the hourly fee. So this does relate to the work that you're already doing by tracking your time. And the reason we're breaking down, looking at it by quarterly, like say a quarter of an hour or 6-minute increments, is because we bill our clients by the hour for the work that we do. I'll talk a little bit more about paralegal time in particular I don't know if it's the next slide or the slide after that, but think of it this way. Attorneys set their own billable rate. That is, how much per hour do they charge the client for their work? And there is a huge range for how much attorneys charge by the hour. It depends on it actually mostly depends on the size of the law firm and the size of the market. meaning the larger the law firm, the larger the city where the work is being done, the higher the fees. A large multinational law firm that is based in New York and has offices worldwide, some of those partners can charge, it's obscene, but $800, $900 an hour for their work. A law firm that is much smaller, working in a smaller town or a smaller city, could be somewhere between $200, $300, $400 an hour for their work. The same is true for paralegal time. Could be $50 an hour that is billed out, could be up to even $75 to $100 an hour for paralegal time. Now you might be thinking, I'm going to make $150 an hour. Remember, that's not what you make. It's what the law firm is billing out for your time. So every hour that you work on the hypothetical Jones matter, the client Jones gets a bill and your name would be there, Hallie Sugarman Paralegal, $75. And then they, the client, pay the firm the $75 for your time. And you, of course, will get a portion of that in terms of your salary, but the rest of it will go to pay for the firm overhead, rent, utilities, copy machines, all the other things that we need to do to keep the office running. So your billable rate is not the same as what you take home, of course. But I want to mention that as part of the hourly fee. So when do we see hourly fees? Honestly, like I said, in most transactions, we bill by the hour because the amount of legal work it takes is unpredictable. So litigation, traditional litigation, a breach of contract, a business litigation, many employment matters, these are all billed by the hour. Same thing to do with corporate formations or acquisitions. These are often billed by the hour. Last but certainly not least is the contingency fee. I was about to start talking about the contingency fee, but I looked over at my notes and I forgot that I wanted to mention something about the hourly fee. And this will relate to that billable matter that we were just talking about. When the client receives the bill for the time the law office spent on their matter, usually the bill will have a section broken out by the attorney billable time, and then it'll include the breakdown of what the attorney did based on the timesheets, much like you all are doing. Then there will be a section for the paralegal time. So the client will be able to see that this is how much they're being charged for the attorney work. This is how much they're being charged for the paralegal work. But what about other charges that might be incurred in connection with a client's case? Here are some examples. Filing a lawsuit requires a fee, usually a couple of $100s to the court just to initiate the case. So something like a filing fee. What about hiring a court reporter to transcribe a deposition that's being taken by the law firm for your client's case? What about making photocopies or sending faxes? Are all of these items stuff, for lack of a better word, that we charge through to the client? Or does the law firm assume those costs and then doesn't bill them out separately to the client? The answer is there's no one size fits all. Some law firms bill through certain costs to the client, especially things like filing fees or copying costs. Some law firms will absorb those costs and maybe just raise their rates a little bit to cover the cost of doing business. The key here in your law office is to find out, as someone who might manage bills, might be the one sending bills to clients. I have some comments on this later. It's important to know how your law firm manages what those are called, like the soft costs, the other costs of doing business that are not just the lawyer time or just the paralegal time. You need to know how your law office manages and bills for that, so that if and when your client has questions about how they're billed, you are prepared to know the answer and then to refer the client to the attorney for any further information. So it's important to know that ahead of time. Now, do we bill the client for things like the cost of keeping the electricity on or the telephone bill, the basic telephone bill? Probably not. But you can see the difference between if I need to photocopy 100 pages of documents for this client versus an electricity bill. Okay, so we got flat fee, We got hourly fee. Now I want to talk about contingency fee. Contingency fee, in short, is that fee you hear about on TV shows and movies where someone comes in and says, I'm injured in a personal injury action and I want to sue, but I don't have any money. That is the most popular place we see contingency fees, are personal injury actions. Also civil rights lawsuits, but mostly in our day-to-day work, it's an extremely popular way of billing work in the personal injury field because there's a legitimate basis for harm and the plaintiff often does not have the resources to pay that very exorbitant hourly fee for representation. So the contingency fee, in short, says the attorney will take a percentage of the award awarded to the plaintiff. There's a nice breakdown of a mathematical equation in your book. You can see how it works, but it's often in the field of 25 to 30%, which might sound like a lot, but again, it's often broken down if you say like, well, how many hours did it take for that attorney and paralegal to be successful in that claim? And then you break it down by hour, it's going to come out reasonably fair. So one thing to keep in mind with a contingency relationship, actually a couple of things. Number one is I will have you take a look at the rule about setting up fee arrangements, and you will see in Massachusetts and other jurisdictions as well that there are specific rules about setting up all of these fees and even its own specific rule just on how to set up a contingency fee arrangement. All of these rules are based in the ethical obligations of being transparent with our clients, explain to our clients how they're going to be billed, how we are going to bill them for our work so that we hopefully avoid any problems in the future. So you'll have an opportunity to look at those. The other reason that I wanted to mention, the other thing that I want to say about contingency fees is actually something that just slipped out of my mind. I was going to tell you about the rules of professional responsibility. And I'm a little embarrassed that I'm making this video and I forgot the other thing that I know what I was going to tell you. I was going to also tell you that sometimes, again, it depends on the firm relationship, is that even with a contingency fee, there are sometimes costs that the client has to pay along the way. And the cost would not be paying for the attorney's time or paralegal's time, but it might be what I mentioned before, like the cost of filing the lawsuit, or perhaps the cost of taking a deposition. There are some of those costs that are billed through to a client, even in a contingency fee relationship. Okay, I was able to say that. All right, a couple of other points that I wanted to make on this initial slide, which I realize has taken me almost the whole video on how clients are billed, how attorneys are paid, is to mention a little bit about retainers. And we're actually going to talk about retainers in our next unit also, but this is a nice introduction. I think many of us have heard the word retainer, and I don't mean the thing that goes in your mouth after you've had braces to hold them in place. A retainer is generally thought of as money that a client gives to their attorney at the outset of the litigation. It could be very large too, think $10,000, $20,000. And the attorney holds on to that money. The part about holding on to the money, we're going to talk about that specifically in our next unit. But what's the purpose of a client saying, here's $10,000, be my attorney? Well, there's two reasons to set up the retainer. One reason is by giving the attorney the retainer, the attorney is agreeing to represent this client and not take on representation of an adverse party in that litigation, that lawsuit. Remember, think about what we've learned about conflicts of interest. So by taking the retainer, it's an agreement that this attorney is going to represent this client in the matter. The other reason to take a retainer is that it's almost like an advance on the money that the client will be paying the attorney for the work to be done. So if there's a pool of $10,000 that has been deposited in the attorney's account, as the attorney does work, the attorney can pay himself or herself out of that account. I'm going to come back and talk about that in our next unit more specifically, and I'm also going to continue this whole section in our second PowerPoint. I'm reaching the end of this one. I will pick up with retainers in just a minute on the other video.